Alright, hi everyone. It's October 7th, 2020. Just coming back to give you some more content, about information security, network engineering. This one particularly is about digital forensics today, talking about phishing and scams and all of that. So I hope you enjoyed today's video, and yeah, please like, subscribe, share, and do all that good stuff. So we're gonna talk about scams. So one scam is sending a setter stating that you have won a sweet stake and asking you to send money to claim a prize. A landmark example. People do that scam often. It says a Nigerian scam list that a lot of people from Nigeria are doing that to people here. Um, A landmark example of a lawsuit involving spoofing email occurred in February 2001 in the Supreme Court of Massachusetts. Sunny Munshani versus Signal Lake Venture Fund 2. Sunny Munshani claimed that he received an email from a CEO of Signal Lake Venture Fund instructing him to purchase options financial warrants for a total of $25 million. Signal Lake Venture Fund investigated its email service and didn't find an email Mashami claimed he received. In preparation for the trial, Signal Lake Venture Fund conducted discovery demand for all of Mashani's email. Because of the sensitive information Mashani had on his email server, the court appointed an impartial discovery firm to examine the email. The discovery firm found that Mashani had used a text editor to alter an email. Wow. The CEO of the Signal Lake Venture Fund had sent. The clue to the email being fake was the enhanced/extended simple mail transfer protocol (ES) number in the message header, which is unique to each message an email server transmits. The email Mashani claimed was a legitimate message instructing him to purchase options had the same ESMT value as the other message of the CEO sent. This level of examination revealed that Mashani committed fraud. Alright, that's very interesting. Exploring the roles of the client server and email. You can send and receive email in two environments, via internet or intranet, an internal network. In both email environments, messages are distributed from a central server to many connected client computers, a configuration called client/server architecture. The server runs an email server program such as Microsoft Exchange server to provide email services. Client computer uses email programs, also called email clients, such as Microsoft Outlook, to contact the email server and send and retrieve email messages. Regardless of the operating system or the email program, users access their email based on permissions the email server administrator grants. These permissions prevent users from accessing each other's email. To retrieve messages from the email server, users identify themselves to the server. To retrieve messages from the email server, users identify themselves to the server as when logging on the network. Then emails are delivered to their computers. Email services on both the internet and intranet use a client/server architecture, but they differ in how client accounts are assigned, used, and managed, and in how users access their email. Overall, an intranet email system is for the private use of network users, and the internet email systems are for the public use. On an intranet, the email server is generally part of the local network, and an administrator manages the server and its services. In most cases, an intranet email system is specific to a company, used only by its employees, and regulated by its business practices, which usually includes strict security and acceptable use policies. For example, network users can't create their own email accounts, and usernames tend to follow naming conventions that email administrators determine. For example, John Smith at some company, J Smith is a username and is followed by the company domain name. No. In an email address, everything after the @ symbol represents the domain name. You need to know the domain information when you investigate email to identify the point of contact at the domain, and you need the domain administrator assistance to collect evidence. In contrast, a company that provides public email services such as Google, GMX, or Yahoo owns the email server and accepts everyone who signs up for the service by providing a username and password. Email companies also provide their own servers. In contrast, a company that provides public email services such as Google, GMX, or Yahoo owns the email server and accepts everyone who signs up for the service by providing a username and password. Email companies also provide their own servers and administrators. After users sign up, they can access their email from any computer connected to the internet. In most cases, internet email users aren't required to follow a standardized naming convention for usernames. They can choose their own usernames, but not the domain name, as long as they aren't already in use. For digital investigators, tracking internet email is easier because accounts use standard names the administrator establishes. For example, Jane.Smith is easily recognized as the email address for an employee named Jane Smith. Tracking internet email users is more difficult because these accounts don't always use standard naming schemes, and email administrators aren't familiar with all the user accounts on their servers. Identifying the owner of the email account with an address such as ittybitty@gmail.com, for example, isn't easy. With an expansion of cloud service providers, many companies are migrating their email services to the cloud. This setup is convenient because employees can easily access their email from anywhere in the world, but it adds a layer of complexity for investigators depending on the server level agreement with the cloud provider. Investigating email crimes or violations. Investigating crimes or policy violations involving email is similar to investigating other types of computer abuse and crimes. Your goal is to find out who's behind a crime or policy violation, collect the evidence, and present your findings to build a case for reprimands, prosecution, or arbitration. Make sure you know the applicable privacy laws for your jurisdiction. For example, in the United States, the Electronics Communication Privacy Act and the Stored Communication apply to email. Let's learn more about those. The Electronics Communication Privacy Act, a law enacted by 1986 to extend the Wiretap Act to cover email and other data transmitted, and the Stored Communications Act is part of the Electronics Communication Privacy that extends to the privacy of stored communications such as email. Alright, that's blocked. Let's Google those words because I do not know too much about those. Alright. The Stored Communication Act is a law that addresses voluntary and compelled disclosure of stored wired and electronic communications and transactional records held by third-party internet service providers. It was enacted as Title II of the Electronics Communication Privacy Act of 1986. So it's voluntary and compelled disclosure of stored wire and electronic communications. Okay, the Fourth Amendment to the U.S. Constitution protects the people's right to be secure in their persons, house, papers, and effects against unreasonable searches and seizures. However, when applied to information stored online, the Fourth Amendment's protections are potentially far weaker. In part, this is because the Fourth Amendment defines the right to be secure in spatial terms that does not mean directly apply to the reasonable expectation of privacy in an online context. The Fourth Amendment has been stressed as a right that protects people and not places, which leaves the interpretation of the amendment's language broad in scope. In addition, society has now reached a clear consensus over expectations of privacy in terms of more modern and developing future forms of recorded and transmitted information. Furthermore, users generally entrust the security of online information to a third party and in a service provider. In many cases, the Fourth Amendment doctrine has held that in so doing, users relinquish any expectation of privacy. Wow. The third-party doctrine holds that knowingly revealing information to a third party relinquishes the Fourth Amendment protection in that information. While a search warrant and a probable cause are required to search one's home under the third-party doctrine, only a subpoena and a prior notice, a much lower hurdle than probable cause, are needed to subject an internet service provider to disclose the contents of an email or of the files stored on that server. Well, that's a lot of wonderful information for you guys today. I hope you enjoyed that information that you got. I'm gonna stop the video there. Please like, subscribe, share, comment, and yeah, help me out, donate, man. This takes up my time, which costs me my money, and but I'm here for you, and let's work together on understanding what's going on with cybersecurity, all right, and network engineering and virtualization and information technology. Basically, let's do this.